But I beg to mention item number 2, my lord. Kindly pass over for the day.
Scan copy receipt, my lord. Scan copy of the copy.
You are appealing for?
Petitioner.
No, you are Mr. HR.
HR.
Yes, Bhattakur and
May it please your lordship, with the consent of the other side, I beg to mention item number 11 and 12.
Bhattakur, yes. 16? 16.5? Look. Where is it?
Yes,
Yes,
I'll
sir.
take this.
Where is the count? Yes,
May it please your lordship, with the consent of the other side, I beg to mention item numbers 11 and 12, my lord. I appear for the appellant.
11 and 12.
My lord.
You are for the appellant?
I am for the appellant, my lord. May I pray this be taken up on 13th of May or thereafter, my lord? As I have an ongoing illness at this point in time, and I have some difficulty in conducting the case today.
And both the matters may be come up together. They have just informed us.
They are together.
We could not know.
I think you are for
Respondent.
For the respondent.
And cross-objector. We have also filed cross-object.
Your good name?
N. Barua.
Okay. So he is taking on 13th of May.
No, my lord. I do not have any objection.
13th of May?
13th of May. Can it be? 13 is not a hearing day, in fact.
Then 14th, my lord?
16 can be. Not
My lord,
14 is other matters that we got.
My lord, then earlier possibly, if possible, because on 16th I'll be out of station. Can it be, my lord, then on that 23rd would be a holiday, I believe. 21st May. Tuesday. It is a Tuesday.
Both the matter will be listed together. We are passing the order.
Obliged.
I'm obliged.
We get the order.
May please your lord. I beg to mention item number 9 of today's list, lordship.
9.
9, lordship. Can it be taken up next week, lordship?
It's a 2008 matter, in fact.
Yes, lordship. Only for the day, lordship. Little accommodation. Any day next week, lord.
Work for,
I'm for appellant, lord.
for the appellant. But the you're in item number 8.
9.
9. So for the end of railway.
Appellant, lord.
No, for the railway.
Yes, lord.
Okay. So I'm
B. Devi.
for whom you have it.
Um,
Your name is there.
Yes, lord.
Okay. Who has responded?
They have not yet appeared, lordship. Notice has been served, but still they have not appeared.
They have not appeared. Yes. 9-5.
Obliged.
May I please, your lordship? Lordship, I beg to mention item number 8, your lordship. Matter may kindly be passed over for the day, your lordship. I am on behalf of MSS Roy, your lordship. Due to some personal difficulties, Your Lordship, she could not appear, Your Lordship.
Have you informed the other side?
Lordship, I have called Mr. JP Sharma, but he is not receiving my call. I'm unaware whether MS Astro has informed or not.
Hard.
FN Jaman?
Right. Yes, it is also old pending one. The old pending one.
Yes, Your
This is
Lordship.
the old pending one.
Lordship may take up it on Thursday, Your Lordship.
That's
Only
not-
accommodation is required for today.
Nine pad. After when you better that they just check. Okay, the nine pad. Nine pad.
Oblige, Your Lordship.
On item 2, my lord. Item 2, my lord. I have already mentioned, my lord. Lordship permitted to pass over it. Put me.
Oh, we are before the date we have to go to. That's why we are.
Oh,
asking
I'm
him.
sorry, my lord. I have seen that my other council is mentioning. Oblige, my lord.
I'd like to mention item number 15, Your Lordship, on behalf of Mr. Biju Fukan. The matter may be adjourned for the day. Lordship, he has over telephone. He has informed me that he has informed as he slept and he suddenly sustained some injury.
That's it.
But he has telephonically informed me that he has informed the others.
After
Obliged. May I please, Your Lordship? Lordship, with the concept of the other set, I would like to mention item number 10, madam. It will come for 2 weeks, madam.
old pending.
Yes, my lord. My lord, H.L. Muria is suffering for illness, my lord.
Who?
Leading counsel H.L. Muria.
Uh,
Last
oh, Robert. It will be disturbed.
Yes, ma'am. Obliged.
May I please, Your Lordship? My lord, we are praying for listing a bail matter. My lord. Second time we have filed on 25, and matter is already numbered, my lord.
When I have it mentioned may not be here.
Lordship, earlier it was rejected
No,
by.
no. That, even apart from that, we to approach it I mean, this the matter for this court. But the
Lordship.
question is, I cannot be allowed your matter.
Right.
Because I'm not just acting as a civil
Lordship.
court.
Obliged.
So,
Item number 3, my lord, charge sheet submitted. May I please, Your Lordship? Lordship, direction may be given to approach the trial court.
hard,
A. Mena. A. Mena on behalf of F1.
hard, report. This number.
CS number 117/24 dated 12/4/24 under section 302/34.
Other section.
302/34.
Right. Right. Right.
Lovely.
May please, your lordship. Item number 4, your lordship.
You are for 4.
4. Bail application under section 439, your lordship. In this case, your lordship, the petitioners are arrested on 7/3/2024. As on today, 54 days behind the bar, your lordship. There are so many sections is added, your lordship. Maximum section is bailable except 87/92, your lordship. And 54 days behind the bar, your lordship. So, lordship, length of detention may be considered, your lordship. And in this case, your lordship, FR page 11, your lordship. Lordship, kindly turn to the page 11, your lordship. FR lodges on, your lordship, 6/3/2024, your lordship, alleging inter alia that the informant came from ISBT to the Jalukbari, your lordship, while he was just standing over this Jalukbari, your lordship. Then one lady came and introduced herself, and thereafter some two conversation, and thereafter, your lordship, she invited to the informant for drinking tea of his house, your lordship. Thereafter he came, went to her house, and suddenly one boy has come and locked the door and beaten him. And thereafter took some money, 2,000 rupees, your lordship. That is the case, your lordship. So, lordship, in this case, your lordship, 54 days behind the bar, your lordship. So, lordship, kindly length of detention. Being a lady, I am paying for one accused, your lordship, Farida Begum. Lordship, 54 days, your lordship.
Earlier also, your lordship has produced this CD, my lord. They are running a racket of prostitution. How, my lord, initially they met in that, my lord, bus stoppage at ISBT. Thereafter, my lord, asked him to come to her residence, and thereafter, my lord, look at that amount, and also, my lord, all these allegations. Well, there are otherwise sufficient materials against the accused.
Only the length.
Only length of other. He along with Saddam Hussein, my lord. She along with Saddam Hussein, my lord. My lord, confined that person, and thereafter that's photographed. And
It was the most probably identified premises where
yes,
it was.
yes.
Being a lady, your lordship, length of detention kindly be considered, your lordship. And in this case, your lordship, if you see page number 18, seizure list, your lordship. Seizure list, page number 18. There are huge amount recovered from this position, present accused and other accused, your lordship. But as per FIR allegation, your lordship, 2,000 rupees was taken from the informant, your lordship. As per FIR and this seizure list, it was different, your lordship. So in this case, your lordship, is whimsically arrested by the police, your lordship.
These
Your
money
lordship,
were
as per
most
FIR.
probably for the
Yes.
purpose of
Lordship,
business, so that's
lordship,
why.
lordship, 54 days behind the bar.
Actually, my lord,
Present
offenses,
petitioner. Being a lady, your lordship, small boy in her house,
they
your
are, my
lordship.
lord, running a racket of prostitution, my lord. They are
Yes.
offenses against society, my lord.
Lordship.
Earlier also, in fact, police warned the house owner, and house owner is also, my lord, item number 5, AB, my lord.
Actual fact of the case is that the petitioner and other petitioners were labor, your lordship, working under the informant, your lordship. When huge amount was balanced, your lordship. There are several times approached and seeking for his payment, but is refused to do so, your lordship. Then he confined when he was not repay the amount, your lordship. That is the actual fact, your lordship. 54 days behind the bar. Any condition may be imposed. I'll cooperate the trial proceeding and investigation as well as your lordship. Being a lady, your lordship.
You will say, yeah,
Yes, Isla.
but the okay. Okay. Yeah, but I that and that it right but
Lordship.
it is pending before which court?
Pending, your lordship. CGM, Kamrup, Metro.
CGM? No, Kamrup.
Yeah.
Dorong Mongol or Kamrup?
Kamrup Metro.
Kamrup.
Jalukbari PS.
Okay, you have done. Okay. Only considering the detention period we have done. Otherwise, there are sufficient. And if the going is appealing for 5, you
They are interim lordship. Both the petitioner are interim lordship. They are appear before the IO lordship.
They were on interim?
Yes, interim lordship. Their petitioner was the owner of the house, but the incidents were occurred, and petitioner is daughter of the petitioner number 1 lordship. They already appear lordship. They are record and petitioner interim. In this regard, 3 persons are already arrested, and Saddam Hussein and one of the son of the petitioner lordship, that is petitioner 1, he was arrested. He is involved in this case.
Their statement is not available in the case very well.
Oh,
No.
but Nazira and Sultana.
No, man, their statement is not available in the case. In fact, bail order, bail bond, and nothing is available in the city.
But the bail order, the bail bond,
Bail bond is also not available in the case.
bail bond is also not
Not available in the
Then,
case.
okay.
They inform me that they appear lordship. I will also.
Then I will get the instruction, Mala.
Today or
Any other
Mala,
the case diary or
I will get the statement on 7th of May.
7th.
Already in interim.
7 holiday.
Or 7th holiday. Then on 10th of May, already they are in interim.
Lordship.
But as per your instruction, they have appeared.
Lordship.
not there. Even Bilbon is not there.
I will contact whether they
Then, my lord, his statement may be recorded. They are the owners of the. One is the, my lord, a petitioner number one is the wife of the house owner, my lord, Mufasil Hussain, and petitioner number two is the daughter of Mufasil Hussain. And their son is also one of the accused, my lord, Miraj Hussain, in the affair.
I think the son is involved.
Yes.
Not that without a
up to date case.
At least return if it return that
Up to date case that he was called for. Whether it is
My lord, already because they are the otherwise there is because only because they are the owners. One is the wife and other daughter. My lord. His statement may be recorded. And CD is up to, my lord, 7324. So, my lord, their statement. So his statement may be recorded.
You don't send back case diary or
I will send back the case diary, my lord.
Up to date case diary.
Otherwise, your lordship may also dispose of the case by recording their statement because
it could have been, but the bail bond is not there.
Bail bond is not there. That is the
up to date case diary was
called. I will get the yes. Then I will get the up to date case diary on 10th of
Lordship, whether it is up to date or not, because earlier up to 7.3 and interim was granted
on 5.4.
5.4.
Yes, sir. It is up to date on up to 7.3.
Yes, ma'am.
Interim was on 5.4. Not up to date.
Yes,
not up to date.
Interim also granted on 10.3, ma'am. 10.3, no?
No, 5.4.
5.4.
5.4, yes.
And up to date, this is not up to date, maybe. I think that's why the bail bond and other things.
CD is up to 7324.
Offset. So, bail order passed, bail order was passed on 5.4.
Melo on 15.5, Melo. 15.5.
Till the interim continued. Master.
Met legal option. My lordship, this is a RERA appeal, my lord, referred against the interim order dated 25/4/2023, passed by the RIAT Assam.
Where is the order?
Order, my lord, will find in page number 110. Page number 110. Here, my lord.
Yes.
My lord, I'd like to highlight the factual aspect of this matter, my lord, initially, my lord. Because, my lord, I am the builder. My lord, I am builder. And he is the respondent, is the participant. In 2015, my lord, he has deposited 10 lakh rupees to me. And subsequently, in 2016 of 30th January, my lord, he had made an agreement with me. Thereafter, my lord, after that, my lord, in 2026, my lord, thereafter no communication between the parties, my lord. 2021, my lord, he filed a case before the RERA, my lord. RERA Assam by claiming he possession initially. And he has also filed the evidence, ex parte evidence, my lord, where he stated that, my lord, that flat have to be handed over to him. Subsequently, my lord, RERA heard the matter, an ex parte order was passed, my lord, by directing to the appellant, my lord, to refund the amount along with the rate interest, that is a compensation. Against that order, I come before the RIAT Assam. RIAT Assam also, my lord, upholded that order by making some justification, my lord. Here, my lord, my contention is this appeal is that, my lord. There is a 10 lakhs, my lord, he has given, my lord, prior to agreement, my lord, that we have executed. After execution of this sale deed, my lord, he have not paid even a single amount, my lord. Even as per the agreement, my lord, there is some slot of the payment, my lord, but no payment has been made. Then, my lord, that reason of the second appeal, my lord, coming for the second appeal is that, my lord, that compensation amount may not be a straightway, my lord. There should be a negligence on my part also, but that part has not established by this, failed to establish by the respondent before the RERA authority as well as the RIAT, my lord. And RIAT, my lord, that this imping order uphold, my lord, that only that transaction part is the, I am also liable to comply with the agreement, my lord. But they have not liable to ensure it because from 2015 to 2021, my lord, there is no sound from the respondent why he has not come forward, my lord. This given before the RERA authority that I have not furnished some particular document which is he has to supposedly submitted before the bank, my lord. But there is no any such letter, such request come from the bank as well as the respondent. Therefore, I am coming before the Sonarpur court. My lord, there is a section 71 of the RERA Act. My lord, have this book, my lord.
Lordship can have my copy.
Section?
My lord, page number 35. Section 70. Why I am referring, my lord, this particular portion. How can the adjudicated of the case and compensation can be determined? Here, my given says that only that, my lord, 10 lakhs, my lord, I have no objection, my lord, 10 lakhs I will return him, my lord. But remand the compensation part, my lord, that compensation he have to establish it is my wrongful wrong or wrong on his part, my lord. That part, my lord. And process of the execution, my lord, how can adjudicate the matter? That is specified in section 71, my lord. Power of the RERA, my lord. May I read, my lord? Power to adjudicate. For the purpose of adjudication, compensation under section 12, 14, 18 and section 19, the authority shall appoint in consultation with the appropriate government one or more judicial officers as deemed necessary who is or has been district judge or two or more judicial officers as deemed necessary who is or has been a district judge to be an adjudicating officer for holding an inquiry in the prescribed manner. After giving any person concerned a reasonable opportunity of being heard. Provided that any person whose complaint in respect of the matter covered under section 12, 14, 18 and 19, that section relating to the compensation bill, in pending before the Consumer Dispute Redressal Forum or the Consumer Dispute Redressal Committee or National Consumer so and so, this is not relevant, my lord. CL number 2. The application for adjudication of compensation under section 1 shall be dealt with by the adjudicating officer as expeditiously as possible as dispose of the same within a period of 6 days from the date of receipt of the application, provided that where any such application could be disposed within the said period of 60 days, the adjudicating officer shall record this reason in writing for not disposing the case within that period. While holding an inquiry, the adjudicating officer shall have power to summon the enforce of attendance of any person acquainted with the facts and circumstances of the case to give evidence or to produce any document which, in the opinion of the adjudicating officer, may be useful or relevant to subject matter of inquiry, and if On such inquiry, he is satisfied that the person has failed to comply with the provisions of any section specified in subsection 1, he may direct to pay such compensation or interest as the case may be. He is think fit in accordance with the provisions of any those section. And section 72, my lord, here, my lord, facts to be taken into account by the adjudicating officer for imposing this penalty. That while the adjudicating officer while adjudging the quantum of the compensation or interest as case may be, under section 71, the adjudicating officer shall have the due regards to the following facts, namely the amount of disappropriation, gain or unfair advantage, waiver qualifiable made in result of the default, the amount of loss caused as the result of the default, the repetitive of the nature of default, such other factors which is adjudicating officer consider necessary to the case in further of inference of justice. Here, my lord, my claim is that, my lord, that compensation part, my lord, there should be a wrong on my part, my lord. That have to be established first, then, my lord, question of this compensation will come, my lord. Suppose, my lord, if negligence on his part, my lord, there I am not liable for pay any compensation. Because, my lord, in my matter, in 2015, my lord, they have deposited the token money of 10 lakhs, my lord. 2016, they have made agreement. My lord, I will show it. In 2016, thereafter, my lord, no payment has been made, my lord. There is a no communication till 2021, my lord. Now, my lord, may please to come the agreement, my lord. Page number 46, my lord. And this agreement is executed on 30th day of January 2026. Here, my lord, the condition is that, my lord, first condition is page number 49, my lord. That is payment clause, my lord. Internet page 3, my lord. That, my lord, last fifth line, my lord. The price of the vehicle package so and so, man, as advance payment against the total considered balance amount will be paid as per a demand made by the builder developer on the following manner. Number 1, 10,000 on the date of executing of the salary. 10 lakhs, my lord. That is already paid, my lord. That is paid, my lord, in 2015, 29/5/2015, my lord. Next, my lord, 5 lakhs at the time of slab casting, my lord. First slab casting, my lord, that 5 lakhs. Second, my lord, 5 lakhs. Third, 5 lakhs. And fourth, my lord, then 5 lakhs. Fifth labor, 5 lakhs. And 6 brickworks of 5 lakhs and 440 lakhs, my lord, at the time of handing over the possession, my lord. My lord, this is an agreement, my lord. Thereafter, my lord, I have starting the project, my lord, after that, my lord, but first slab casting, he has not paid the 5 lakhs, my lord. And I have made request him to pay, my lord, but his evidence he said, my lord, that I have request him to pay, my lord, but he has not paid, my lord. This is the violation of the clause, my lord. Here, my lord, RI authority said that this clause has to be complied by the builders only, not by the purchaser. And, my lord, page number 51, that is the condition of the agreement between the parties, my lord. Number 1 condition, my lord, that is in regards to the streak in the payment, my lord, that the builder agreed to construct the flat apartment and on the completion of it will be handed over to the purchaser and residential flat as per the design and specification given in Schedule B and on completion of the construction on the condition that the purchaser pay the full consideration timely and strictly in manner herein prescribed, and that the purchaser shall comply with all other terms and conditions of this agreement and fulfill the same before taking over the possession of the unit prescribed in Schedule B. This is, my lord, very much strict, my lord, because, my lord, he have to pay as per this agreement, my lord. But from 2016 to 2021, there is no payment, my lord. And number 2 condition is that, my lord, the purchaser agreed to pay the money at the time of period stipulated as between the parties. On failure to pay any breach committed by the purchaser to the non-observance thereof, this agreement shall, at the opinion of the builder, be terminated, and builder shall be at liberty to refund the money after deducting 5% of total cost of the flat and necessary relevant expenditure as applicable, my lord. This is the clause. If he failed, my lord, then we can deduct, my lord, and we can refund it, my lord. And, my lord, clause number 4, my lord, that is related to the construction work and documentation of the builder, my lord. And clause B, my lord, the purchaser shall be entitled to take possession of the said premises as contemplated under subsection A herein above, only after he has duly observed and performed all the obligations and stipulations contained in this agreement, and has fully paid the builders whatever amount payable by the purchaser under this agreement. This part also, my lord, ignore, my lord. And clause 10 is also very strict, my lord, that the purchaser shall not be entitled to take possession of the said building until and unless all payment required to be paid as per this agreement as has been paid to the builder by the purchaser, my lord. And initially, my lord, arbitration clause also there, but subsequently RERA Act says that, my lord, arbitration is not required. Therefore, we are not placing the arbitration clause. Then, my lord, will file the money receipt, my lord. Then 29/5/2015, that is prior to execution, my lord, that 2 money receipt executed, page number 62 and 68, my lord. Then, my lord, 2021, they filed a complaint, my lord. My lord, will file complaint, page number 65. This is the complaint file, my lord. They have highlighted the facts in page number 66, my lord. What is their grievances, my lord? Page number 66, my lord. That is the grievance of the respondent, book a flat under Messrs. Bipul Construction, proprietor Messrs. Bipul Bharali, but he handed over the flat allotted to the third party, depriving me and my booking amount of 10 lakhs, which is an act of fraud. And subsequently, my lord, this petition filed only his grievance, my lord, only that much of grievance. Subsequently, he developed his case by filing the evidence, my lord. Then this part, my lord, he has not stated, my lord, why some documents required. I have not provided the documents. That part is not a part of the records of the original complaint petition, my lord. They have not stated anything, my lord. And subsequently, in evidence part, he has been in his facts, my lord. That evidence, my lord, he said, my lord, but the builder, Mr. Bipul Bharali, instead of providing the required document for submission, the same to the concerned bank SBI for sanction of the complainant's loan, he on demanding money from me. That is the, my lord, prima facie evidence that I have demanded money as per this particular agreement, my lord. But he has ignored, my lord. And even that, my lord, he is saying that some document is required in the bank, my lord. But there is no any document to show before this RERA authority as well as RET, my lord, that this document is required to be handed over to that person, my lord. He has taken plea, my lord, in the evidence only, my lord. And even till that, my lord, I have no knowledge about that, my lord, what document he is required, my lord. Some document, my lord, before that is the public domain, my lord. He can get any time, my lord. And other, if my personal document is required, my lord, before filing of that case, at least he should intimate, my lord. He has also, my lord, stated that on the 16/1/2020, he has sent a legal notice, my lord, but we have not received the legal notice as well as notice from the RERA, my lord. And that one document, my lord, he has enclosed, page number 100, my lord. This document, my lord, he has submitted before the RERA authority. But, my lord, from this document, my lord, we cannot ascertain that what document is required properly by the bank, my lord. There is no requisition from the bank, my lord. That, my lord, title deed, Jama Bandi, that is available, my lord, mutation, that will become subsequently power of, general power of attorney, that is also available, my lord. Then personal affidavit, my lord, sole proprietorship affidavit from the builder. Non-incumbent certificate, my lord, that is also a part of the public domain, my lord. Valuation of the flat, last salary statement, that is his personal, my lord. From this document, my lord, we cannot also ascertain that what document is required, what document I have to furnish him. Because there is no any demand letter from him, my lord. Page number 100 is the MP order, my lord, by the RERA authority. And page number 110 is the RET, my lord. Here, my lord, we have met contention before the RERA as well as the RET authority, my lord, in the entire act, my lord, that legislated by the register only two duties of the buyer, my lord. That is specified in section 19, my lord, subsection 6 and 7, my lord. That is the only duty or duty and responsibility of the purchaser, my lord, to pay, my lord. My lord will come to the bit, page number 18, my lord. Page number 18 of the book, my lord. Right and duty of the allotment. He has some right and some duties. From 1 to 11, my lord, their rights only, my lord, in regards to serial number 6 and 7, that is the duty of the allotee, my lord. Purchaser have only that duty, he have to enter the agreement here and he have to pay, my lord. And, my lord, in various cases of law, Supreme Court also take up, my lord, there is no protection for the defaulter, my lord. Supreme Court has not adjudicated any matter where defaulter is there. In case of full payment made, then case taken account, my lord. And, my lord, this RET authority, RET, my lord, they have ignored the right and duties of the both parties, my lord. They are saying that only in regards of the payment, my lord, I have to be made demand, because it is the evidence says, my lord, I have already made demand, my lord, but they have not paid, my lord. That responsibility has ignored, my lord. And section 19 and 19(7) has violated. And, my lord, Tarzan Singh case, my lord, one of the case of the Supreme Court, my lord, where stated that, my lord, in regards to the payment, my lord, within a specific time that have to be claimed, my lord. Because, my lord, when, my lord, is made 10,000 in 2015, my lord, how can I suffer, my lord? From 2015, he paid 10 lakhs, my lord. In 2015, my lord, he paid 10 lakhs to me, my lord. And as per the agreement, my lord, I have to be complete the entire work, my lord, within a specific time, my lord. And from the date, my lord, prior to the first slab casting, he have to pay 5 lakhs to me, my lord. He has not paid, my lord. Therefore, my lord, I have to suffer, my lord. I have to construct the building, my lord. Even he have not paid the 5 lakhs, then I have to construct the building, my lord. Accordingly, in second slab, third slab, my lord, I have to expense, my lord. This is my business, my lord. I have to invest my amount, my lord. I have to invest because he has not paid. Therefore, I cannot ignore his part, my lord. I have to build up that part also, my lord. Otherwise, my lord, he is suffering. He is projecting that he is suffering. I am also suffering, my lord, similarly. That, my lord, that tribunal that failed to justify from the various decided by the RERA that considered whether purchaser may pay against a deal as per the agreement of sale, my lord. The agreement for sale, my lord, he have to pay, my lord. But this particular clause they have ignored, my lord. And my lord, this impugned judgment, they have reflected that the appellant may have been with its right to question the action of the respondent. Complainant is not making the balance payment or in not complying the subsection 6 of section 19 of this act, but the appellant itself having ignored to abide by the obligation imposed upon it by the agreement for sale governing the manner with regard to the payment of balance amount. Therefore, assertion of right in its favor to the detriment of the respondent complaint is not available to the appellant. My lord, rate authority, they has justified that payment, making the payment, not making the payment is the bad action of the respondent, even though they had imposed the penalty, my lord. And as per the clause 2 of this RERA Act, my lord, appellant is protected, my lord. He can cancel this deed, my lord, if he has not paid properly, my lord. As per the terms and condition, if he has not made, my lord, that is clause 2 of this agreement, my lord. And my lord, I am specially placed before this court, my lord. Then, my lord, this is the strictly violation of the section 70, 71 and 72 of the RERA Act. Because, my lord, prior to imposition of the penalty, my lord, that quantum of the damage that have to be ascertained, my lord. Who has suffered actually that loss, how much loss to the purchaser, my lord, due to inaction or election on my part, my lord. But that part they have not ascertained, my lord. And if we are going to the, my lord, the question of the agreement, that Contract Act as well as Specific Performance Act, my lord, that both acts said that both party has equal right and liability, my lord. That have to be, payment part have to be considered by the both party equally, not by the one part, my lord. In this impugned judgment, my lord, they have considered only one part, that payment that I have not handed over the flat, my lord, and that document I have not handed over, my lord, that part, my lord. Now, my lord, therefore, I am placing before this honorable court, my lord, this is the strictly violation of the section 72, because this compensation that awarded by the learned RERA authority, my lord, that is not as per the section 72 of the Act, and that is without the adjudicating without the determination of the quantum of the compensation, my lord. Therefore, my lord, I am placing, my lord, this order may be set aside.
My learned friend has made long submissions, my lord, but then the basic issue here is, my lord, it has to be heard on substantial questions of law. Lordship, may kindly take up page 58 first. I'll come to the facts, my lord, later on, because my learned friend has placed a lot of facts, my lord. Section 58, my lord. This is a, my lord, second appeal, basically a second appeal, my lord. It will be hard on questions of, my lord, substantial questions of law only under section 100 of the, my lord, CPC, my lord. And 58, my lord. And many of the issues that are being raised for the first time in a second appeal. That is not permissible, my lord. Section 58, your lordship will find appeal to High Court. Any person aggrieved by any decision of the on order of the appellate court. So already appellate court has already decided, may file an appeal to the High Court within a period of 60 days from the date of communication of the decision of the appellate court to him on one or more of the grounds specified in section 100 of the CPC, provided the High Court may entertain appeal after expiry of the period of 60 days if it is satisfied. So it is under section 100 of the CPC, which means substantial questions of law only. So initially, when my learned friend filed this application, he filed it without any substantial question of law. Then he was asked to, my lord, frame this substantial question of law, my lord, and he has placed certain substantial questions of law, my lord. In my humble submission, my lord, none of these questions are substantial questions of law, my lord. But the simple reason, my lord, first of all, my lord, yes, but page 25 with the substantial question of law, my lord, that my learned friend is framed, my lord. Now, the first question that has been framed, my lord, is that non-framing of the points of determination. Now, my lord, this is not required under the RERA Act. In the RERA Act, my lord, there is no requirement of framing of any issues or point of determination. So, therefore, this question, my lord, is not at all a question of law, my lord, which can be entertained in the RERA appeal, my lord. Because in the RERA Act appeal, my lord, unlike in the Civil Procedure Code or any other process, my lord, there is no necessity to frame any issues. So, what the first question that my learned friend has framed is that whether the learned first appellate court below erred in not framing the points of determination for determining the appeal as provided under Article 14 of the Constitution of India. My lord, this is totally, my lord, not required, my lord. There is no requirement of framing any points of law for determination. So, therefore, this question is not at all, my lord, important. My lord, not a substantial question of law in this case, my lord. Then, my lord, whether the respondent is entitled to compensation without determining the quantum of damage. Well, that I will come later, my lord. I will make my submissions of that, my lord, because that is the submission perhaps where, my lord, he has made elaborate submissions. I will counter that, my lord. For the substantial question of law is whether the case of the respondent is for specific performance of contract and is hit by Article 54 of the Limitation Act. My lordship knows, my lord, limitation, my lord, or my lord, limitation is a matter of, my lord, facts and law, my lord. And this is being, for the first time, it is being urged in the second appeal that is not permissible law. I'll rely upon a judgment. So this question also goes, my lord. Now, for the question, substantial question of law is number 4, whether respondent is entitled to relief given by the learned tribunal who violates provisions of section 19, 6 and 7 of the RERA Act by ignoring the prima facie records. That I will also come to, my lord, make my submissions. And the 5th, my lord, is that whether the substantial question of law is whether the learned appellate court is entitled to justify the concept of rights in favor of respondents by ignoring the principles of law, duties related to each other. And this is, my lord, totally vague question, my lord. This is totally, my lord, a question, my lord, which is, my lord, in fact, it is trying to cover all the questions, my lord, but it is not a question of law at all, my lord. So, therefore, the only question that remains, my lord, is whether the compensation has been determined, my lord, and whether there is a violation of 19.6 and 19.7, my lord. The lordship will find, my lord. Lordship will take up the impugned judgment once. Before that impugned judgment, Lordship will first take up the judgment of the tribunal, my lord. Not the appellate tribunal, my lord, the RERA code, my lord, 101, my lord. Page number 101. Now, my lord, in that proceeding, my lord, they did not appear in the case, my lord. In spite of opportunities, my lordship will find at page 106. There may be some, my lord, mistake in the page number. My learned friend is referring in the one page number mistake. I don't know, my lord. It may be 106 or 107, my lord. It starts with order at the top, my lord. 106, my lord. After going through the documents on record and hearing the learned counsel for the complainant, it is apparent that an agreement for sale dated so and so. But the first floor of Radhika enclave was executed by the complainant and respondent. The complainant also made payment of rupees 10 lakhs, 2 installments, 5 lakhs each. In the absence of the respondent's appearance, and submission before the authority despite sufficient opportunities afforded to him. We are not aware of the circumstances as to why the respondent sold the allotted apartment to third party without informing the complaint. So in fact, my lord, he sold the complaint, my lord, after I, my lord, before I lodged the complaint, he had already sold the, my lord, property to someone else, my lord, without informing me. My lord. So therefore, there is nothing on record to show, my lord, the court has held, my lord, that there is nothing on record to show, my lord, as to why he had sold the, my lord, flat to a third party, my lord, without informing me, my lord. Then, my lord, lordship will, my lord, I can, my lord, section, my lord, sections have been discussed, my lord. Then, my lord, lordship will kindly turn to, my lord, page 107, my lord, where there is a stipulation of interest, my lord. Rule 17, my lord. I'll come to that, my lord. Rule 17, my lord, page 107, my lord, about, my lord, 1, 2, 3, 4, 5 paragraphs, my lord. Rule 17 stipulates that the rate of interest payable by the promoter to the LOT or by the LOT as the case may be shall be by the state bank at the state bank's marginal cost of leading plus 2%. So, my lord, there is a specific, my lord, provision made, my lord, with regard to payment of interest, my lord, and that is what has only been awarded, not compensation, my lord. That is the, my lord, basic difference, my lord. That also I'll show, my lord. What has been paid here, my lord, is apart from, my lord, 10 lakhs, my lord, the interest, my lord, not compensation. Because compensation and interest are two different things, my lord. And for the purpose of, my lord, determination of interest, my lord, the rate has been specified. The tribunal and the appellate tribunal has both, my lord, computed the interest in terms of the rule specified, my lord, not by going beyond that, my lord. When it comes to compensation, my lord, then there has to be an adjudication, my lord, over the losses and all, my lord. So that's a separate chapter altogether. So therefore, my lord, the learned court, my lord, awarded the compensation on the basis of the complaint made, my lord, and lordship will also find, my lord, that the learned tribunal has taken into account, my lord, the part of the agreement. Again, lordship, I'll try to, my lord, just place, my lord, page number. The agreement I'd just like to place before lordship once again, my lord. That particular clause of payment, my lord. The clause of payment is very relevant, my lord, because that determines, my lord, clauses payment 70 my lord, 9, my lord. Lordship will see, my lord. I'll read, my lord, from the bottom, my lord, about 1, 2, 3, 4, 5, about 10 lines from the bottom, my lord. The price of the vehicle, my lord, the price of the vehicle parking is included in the value of the flat, and the proposed purchaser has paid a total amount of rupees 10 lakhs only as an advance payment against the total consideration. And lordship, this is very relevant. The balance amount will be paid as per the demands made by the developer builder in the following manner. So, my lord, 10% on the date of execution of this deed, 10 lakhs, then only that has been deposited, well, 5 lakhs at the time of casting the first slab, 5 lakhs at the time of casting second slab, 5 lakhs at the time of third slab, and so on and so forth. Now, therefore, the demand has to be made. Therefore, the learned tribunal has come to a specific finding, my lord. They have not been able to project, my lord, when the demands were made. So that demand not having been made, my lord, the learned tribunal has held, my lord, that this obligation on part of the, my lord, the LOT, my lord, the respondent here, my lord, did not arise. He had to make a demand. I have casted the first slab, or the first slab is casting, ready for casting. You make this such payments. Those demands were not made, my lord. And the learned tribunals have come to specific findings on that, my lord. Lordship, if the lordship takes up the, my lord, impugned order, my lord, the first of the appellate court, my lord, the appellate court has, my lord, discussed that, my lord. Page, my lord, 110 it starts, my lord, and 111 it starts, my lord. Clause, my lord, page 118, my lord. And before that, in paragraph, sorry, my lord, clause, my lord, page 116, my lord, paragraph 10 onwards, my lord, that may be relevant, my lord. As regards 116, my lord, page number. As regards the alleged argument of violation of subsection 6 and 7 of section 19 of the Act on part of the respondent complainant, we are of the opinion that the applicability of subsection 7 is conditioned upon a specific satisfaction that the allotee has failed to discharge his responsibility mandated under subsection 6. The said subsection obligates every allotee who has entered into an agreement for sale to take up an apartment to be responsible for making necessary payments in the manner and within the time specified in the agreement for sale. If the violation of the said subsection is alleged, then the fact of failure on part of the allotee in discharge of his responsibility to make the payments in the manner and within the time specified in the agreement for sale has to be firmly established. In the instant case at internal page 3 of the agreement for sale, the manner of making payment is given, the relevant portion which is reproduced here and there, which I have just read before in the agreement, so I will not read it once again. From the above, it is seen that the respondent complainant has paid an amount of which 10 lakhs as advance, and the balance amounts duly quantified are to be paid when the particular event takes place and as per demands made by the builder. Emphasis supplied. Apparently, there is not an iota of evidence or document borne on record to substantiate that the appellant had apprised the respondent complainant of any events occurring or had made any demand for payment of the balance amount at any given point of time. There is an inexplicable silence in this regard on part of the appellant. On the above count, the question arising as to whether the appellant can be allowed to allege violation of subsection 6 of section 19 of the Act when it had itself disregarded the essential provisions of the agreement governing payment of balance amount. Surely the appellant cannot be allowed to blow hot and cold at the same time. The law on this point is clear. In the case of so-and-so, the Supreme Court in paragraph number so-and-so, the law doesn't permit a person to both approbate and reprobate. In so-and-so versus so-and-so, the Honorable Supreme Court in paragraph 23 thereof has held that the maxim so-and-so means that the one who approbates cannot reprobate. It is firmly embodied in the English common law and is often applied by the courts in this country. It is akin to the doctrine of benefits and burdens, and which is at its most basic level provides that the person taking advantage under an instrument which both grants a benefit and imposes a burden cannot take the former without complying the latter. In the facts of this case, the appellant may have been within its rights to question the action of the respondent complainant in not making the balance payments and in not complying with subsection 6 of section 19, but the appellant itself has ignored to abide by the obligations imposed upon it by the agreement of sale governing the manner in which regard to the payment of balance amounts. Therefore, assertion of any right in favor of to the detriment of the respondent complainant is not available to the appellant. So therefore, my lord, thereafter, my lord, paragraph 12, my lord. Clause 2 of the agreement for sale provides that the purchaser shall pay money at the time period stipulated between the parties. In absence of any time fixed for payment of money in the agreement, the clause is to be read with the conditions stipulated in internal page 3 of the agreement, where the money is to be paid on the particular event taking place and as per demands made by the builder developer. To reiterate, there is no material to show that the appellant builder had made any demands on the respondent complainant for payment of money or had any time informed the respondent complainant of any of the events taking place supporting the demand of the money. So he has to say that I am casting the first slab to give me this money. Second slab, given this money. There is no demand as such. It is seen that the consequences for violation of clause 2 is also provided, so much so that on failure to pay by the purchaser or non-observance thereof, discretion is given to the builder to terminate the agreement with liberty to refund the money after deducting 5% of the total cost of the flat. Clearly, there is no material record evidencing that the agreement for sale dated so-and-so had ever been terminated on ground of failure of the respondent complainant to pay the money. So she will find that they had also the option to really terminate the agreement, which also they did not do. There is no material to show that the appellant builder had exercised his liberty to refund of the money admittedly received from the respondent complainant after making such deductions as provided in the clause 2 of the agreement. In fact, the first that the allotted flat was sold off to a third party by the appellant bidder is also a disputed fact. More importantly, there is no evidence to show that the respondent complainant was given prior information, was taken into confidence of the sale of the transaction taking place, of the said transaction taking place. It was a transaction executed behind the back of the respondent complainant, which, so to say, cannot have the sanction of law. Therefore, the above facts of the case appellant cannot be heard to say that the respondent complainant was not entitled to equity due to the alleged lapses in payment of money and for keeping quiet for a period after execution of the agreement of sale dated so-and-so until the year 2019. Such argument does not merit any consideration. From the discussions and the findings above, we are of the view, and in view of the statutory provisions of the subsection 1 of section 18, read with the rights and entitlements of respondent complaint to claim refund of the amount paid along with interest enjoined in subsection 4 of section 19, we unhesitatingly uphold the order of under appeal dated 13/2010/2022 passed by the RERA Assam. Consequently, we find no merit in the present appeal and we accordingly stand dismissed. However, no cause. Before we part of the appeal, we place on record the following following our orders dated earlier orders dated 16/12/2022, 19/1/2023 and 7/2023, the appellant had deposited an amount of rupees 7,40,774 with demand draft number so drawn on the Central Bank of India in favor of the Assam Real Estate RERA Appellate Tribunal towards compliance of the provisions to section 5, subsection 5 of section 43. The said amount was determined by adding the total consideration money which the appellant was directed to return to the respondent complainant by the RERA, together with interest thereupon imposed. Thereupon in terms of Rule 17 of the rules, computed until the date of filing of the appeal, which is 13/12/2022. The basis of compensation of the rate of interest is clearly spelled out in paragraph 7 of our earlier order dated so-and-so, which is reproduced hereunder. So, this order of payment of compensation was not the final order, my lord. In fact, it was issued much earlier, and had that deposited the money without making any complaint or filing an appeal against that. Now, in working out the interest on the principal amount of rupees 10 lakhs, we have considered the prevailing State Bank of India's marginal cost of lending rate, my lord, which is prescribed under Rule 17, my lord, as available in the official website of the State Bank of India. We find that the lending rate amount announced on 15/12/2022 is 7.85% to 8.60% per annum. Taking the interest payable in terms of SBI's marginal cost of lending rate at 7.85 and adding an additional 2%, which comes to 9.85 per annum as per direction of the RERA and Rule 17 of the rules, the interest payable on the first 5 lakhs with effect from 25/2015 at least until the date of filing of the instant appeal, that is 13/12/2022, covering a period of 7 years, 6 months and 15 days, the pre-deposit amount on the interest component works out to be to rupees 3,71,399. Similarly, on the second amount, works out to rupees 3,69,375. Thus, the total amount of deposited to be deposited by the appellant with this tribunal in strict terms of the provisions of section 5 of section 43 of the Act before the appeal can be entertained is quantified as 17,44,774. So before entertaining the appeal, this amount was quantified and this was had to be deposited. So therefore, this, in my humble submission, will be again different from the compensation. Now again, Lordship takes up section 71 once. My friend has placed it, but I would like to take Lordship's indulgence to place it once again, page 71. For the purpose of adjudicating compensation under section 12, 14, 18 and section 19 of the authority shall appoint in consultation with the appropriate government one or more judicial officer as deemed necessary, who has been or is or has been a district judge to be adjudicating officer for holding an inquiry in the prescribed manner after giving any person concerned a reasonable opportunity of being heard. So it is only for the purpose of compensation under section 12, 14, 18 and section 19, my lord, authority is to be, my lord, appointed. Now what is 12 section 12, 14 and 18 and 19, my lord? Section 12, Lordship will find, my lord, at page 15, my lord. Obligation of the promoter regarding veracity of the advertisements on prospectus, my lord. This we are not concerned because here there is no dispute with regard to that, my lord. So, my lord, this is one place, my lord, if the promoter makes a wrong, my lord, advertisement, my lord, wrong, my lord, prospectus, my lord, then, my lord, that obligation of compensation comes in, my lord. So, section 12 is not affected here, my lord. Non-deposit of advance taken by the promoter with first entering into an agreement, my lord. Section 13, that is the next section 13, my lord. Non-deposit or advance to be taken by, no deposit or advance to be taken by promoter with the first entering into an agreement for sale, my lord. This also we are not concerned here, my lord. Second, adherence to, my lord, then comes section, my lord. Sorry, 13 is not relevant, 14, my lord. adherence to the section plan and project specification by the promoter. Here it is not a case, my lord, that we are saying, my lord, the project has been, my lord, done something, my lord, in violation of the, my lord, promotion, my lord, what was, my lord, specified in the project, my lord. That is also not the case. So 14 is not applicable, my lord. Then, my lord, 18, my lord. 18 is, my lord, return of amount and compensation, my lord. If the promoter fails to complete or is unable to give possession of the apartment plot or building in accordance with the terms of this agreement for sale, or the case may be duly completed by the date specified therein, due to discontinuance of his business as a developer on account of suspension or revocation of the registration of the flat under this act for any other reason, he shall be liable on demand to the allotee, in this case to the allotee, wishes to withdraw from the project without prejudice to any other remedy available, to return the amount received by him in respect of the flat so and so, as the case may be, with interest at such rate has been prescribed. So interest rate has been prescribed, my lord, under Rule 17, my lord, in this behalf, including compensation in the manner provided under this act, my lord. So compensation, my lord, and interest are two separate components, my lord. Section 18, my lord, says that he will be entitled to interest and compensation in the manner provided, my lord. Now, compensation has not been provided in this case. What has been provided only is, my lord, the interest, my lord. And lordship will kindly, my lord, then turn to Rule 17, my lord, of the rules, my lord. That has been, my lord, discussed by the learned tribunal, my lord. (17), my lord. Yes, my lord. Rule 17, page 53, my lord. Rate of interest payable by the promoter and the allotee. Page 53, Rule 17. The rate of interest payable by the promoter to the allotee or by the allotee to the promoter, it can be either way, my lord, as the case may be, shall be the State Bank of India's marginal cost of lending rate plus 2%. So therefore, my lord, the rate of interest is something which is already specified under the Act, my lord, on the rules. And that is what has been awarded, not the compensation, my lord. So when my learned friend is saying, my lord, the section 71 and 72 has been violated, my lord, that would have been a case, my lord, had it been a payment of compensation. Because for compensation, my lord, an authority is to be appointed who is a district judge or a former district judge, my lord, who can determine the compensation. Because compensation is a separate issue altogether. There has to be adjudication what is the violation, what is the loss out of the violation. But interest is paid on the money that has been used by the builder, which I had paid 10 lakhs, which I had already paid, and that he has used for all these years, and depriving me of the benefit of the money. That is the interest which is payable. So the learned tribunal has only awarded interest, my lord, not the compensation. So therefore, this question, my lord, section, my lord, with the 71 and 72 is violated. This is also not an applicable question in this case, in this particular case, my lord. And so far as, my lord, violation 19, my lord, section 19, my lord, 6 and 7 are concerned, my lord. 19, 6 and 7 are concerned, my lord. That lordship will find the rights and duties of the allottees, my lord, at page 19 of the, my lord, Act, my lord. True, my lord. We have to make the payment as per specification in the agreement. But what the agreement says, we are not disputing that we don't have to pay as per the agreement. But what the agreement says that you have to make a demand to me. I'm casting the first slab, pay 5 lakhs. I'm casting the second slab, pay 7 lakhs or 5 lakhs. I'm casting the third slab, pay another 5 lakhs. Those demands, the learned tribunal, both the tribunals found, because the first court they did not appear. In the trial appellate court they appeared, but they did not produce any document to show that they had made this demand saying that we are casting the first slab, because the learned tribunals found that they neither made any demands nor made any given us an information that such specified events has taken place. What is those events? The events are casting of the first slab, casting of the second slab. Those events have to be told to me and specified to me. Only then the payment can be released. And my lord, this was a question of payment by the bank. This is a loan. What happens, my lord, in all these cases, my lord, the builder makes a payment, my lord, request to the bank itself. Kindly release this much amount. The first slab is being counted. Nothing of that sort, my lord. Therefore, the learned tribunal has said, my lord, both the learned tribunals have held, my lord, that the appellant were, my lord, guilty of, my lord, not, my lord, handing over the flat, rather selling it to some other person, and without any intimation. Therefore, they are not entitled, since they have not made any demand, my lord, they are not entitled to any money from me, and they are entitled to, rather, they are liable to refund the money along with interest, which is already specified under the rules. The court did not go into the amount of compensation. The court did not give me any compensation. So whether this entire substantial questions of law that has been, my lord, framed, my lord, have got no application in this particular case. So therefore, this is my humble submission, my lord. This case is liable to be dismissed, my lord, and limine, my lord. Or otherwise, if your lordship, my lord, even otherwise, my lord, assuming, my lord, if your lordship is inclined to, my lord, frame any substantial question of law, my lord, then it is to be heard in final hearing, my lord. That's only at this is only for the stage of, my lord, admission, my lord. This matter has come. But in my humble submission, my lord, there is no substantial question of law involved in this case, my lord, and this is liable to be dismissed. And the other questions, my lord, with regard to limitations and all, my lord, these are, my lord, questions of fact and law, my lord, which cannot be raised for the first time, first time in a, my lord, second appeal, my lord. This is one of the judgment, my lord. You have to, my lord, because limitation is a question of my lord, mixed question of law and fact. You have to show, my lord, when the limitation starts, why the limitation starts, and this and that, my lord. Nothing of that sort, my lord. My lord, here for the first time, this is one question about tenancy question. This is with about tenancy, my lord. This question was raised for the first time in a second appeal, and the High Court rejected it in there. And the Supreme Court said, my lord, there is nothing wrong in that, my lord. My lord, it is, my lord, about, my lord, there's only, my lord, 2 paragraphs only, my lord. The second paragraph, my lord, from something, my lord, from the bottom middle, my lord. A new plea based on Section 2A was sought to be raised for the first time in the High Court. The High Court rightly did not permit the appellants to raise the plea of the deemed tenancy, as the said claims needs investigation based on factual foundation which are lacking. So, my lord, in my submission, my lord, if you are raising a question of limitation, etc., my lord, you have to bring the factual foundation there. You did not. You did not appear in the before the tribunal first. It is only in the appellate tribunal you appeared. There also you did not give anything. Now, for the first time, you are raising these questions of limitations, etc. So, therefore, in my humble submission, my lord, no substantial questions of law have been, my lord, projected in this case, my lord. And the questions which have been raised, my lord, if any at all, my lord, under, my lord, violation of Section 71 and 72, my lord, that is not applicable in this case because no compensation has been awarded. It's only the interest, my lord, for which, my lord, the parameters are already there. There need not be any adjudication. No one is to, my lord, calculation does not need any adjudication. But compensation, the loss, if it is to be asserted, then only the question of compensation, my lord, adjudication comes. Then perhaps the district judge level officer, my lord, will perhaps look into, my lord, whether the compensation, or what is the loss, what is the, my lord, gain, whatever. So here, only the interest has been awarded. My lord. That's my submission.
My lord, I'd like to reply only few points which is raised by my learned senior friend, my lord. First of all, my lord, deposition of that 17 lakh amount. That is, my lord, we have no option because, my lord, we have to deposit before the period, my lord. That is the statutory provision. Therefore, we are deposited on the basis, my lord. Initially, my lord, the interim order was given, my lord, for stay of the order. Now, my landlord friend said that there is a no, that is the not a compensation, that is the interest, my lord. Now, my lord, then question is arise, my lord. If it is the question of the interest, my lord, that interest, only interest can be given when the deposition is given to me or particular bank. Even I am not authorized to giving the interest, my lord, even particular bank, my lord, then there will be no condition, my lord. Without any condition, my lord, if the party concerned is depositing before the bank, my lord, then, my lord, question of the interest will come, my lord. Then that part, my lord. And, my lord, that it is the imposes a compensation because, my lord, otherwise there is no any agreement between us that he has lending, I have to take the money as loan, my lord, I have to give him the royalty, my lord, there is no condition, my lord. This is the specific condition, my lord, for the purpose of this, that taking the bill of building only, my lord. And second, my lord, that, my lord, 10 lakhs, my lord, why I am not giving that 10 lakhs, my lord, because, my lord, then, my lord, I am also equally suffered. I have already highlighted, my lord. Because, my lord, I am builder, my lord, I have to take loan from the concerned bank, my lord. I have to pay the installment, my lord. Therefore, I am taking loan for constructive building, my lord. Even, my lord, without paying that, my lord. So that part, my lord, that if, my lord, if going to the factual aspect, 2016 to 2021, my lord, no communication, my lord. Even, my lord, I have repeated. no, that part, my lord, RERA Act has specifically stated in section 25 that in that case that RERA can conduct an inquiry, my lord, in regards to that respect, my lord. Therefore, RERA authority has not considered on that part, my lord. That because that separate, my lord, that is independent inquiry is required for that part, my lord. And that is also not claimed, my lord. Now, my lord, I am just trying to project, my lord, that 7 lakhs amount is a compensation, not as an interest, my lord. Because, my lord, I am not liable for pay the interest, my lord. Because, my lord, this is not an unconditional deposition to me. I cannot utilize it, my lord. That is as per the agreement. And I am also equally suffered because I have to pay the installment, my lord. And my learned friend arguing one point, my lord, then there is no demand from me, my lord. I just like to highlight it from his evidence, my lord, which is submitted before this court, my lord, filed before this read, my lord, on oath, my lord. Then, my lord, he has stated that repeatedly I am request for the money, my lord. Then, my lord, will find in page number 69, my lord. Page number 69, my lord. That is evidence, my lord, filed by the respondent before the rate, my lord. That is expert evidence. If my lord go to the serial number 2, my lord, 5th paragraph, my lord. Bipul Bharali, instead of providing the required document, my lord. What document, my lord? Still the entire proceeding, my lord, there is no clarification from it, my lord. What document they required, my lord? Providing the required document for submission of the same concerned bank, SBI, for sanctioning the complainant's loan, keeping on demanding money from me, my lord. Then, my lord, it is admission from himself, my lord, that I am demanding the money as per the disagreement, my lord.
Documents are very much there, my lord. It's not.
Otherwise, my lord, if it is stated on oath, my lord, then why documentation evidence is required, my lord? He has taken on oath, my lord, not before the any authority, even authority concerned, my lord.
Specifically stated what documents cannot furnish, my lord.
But
these demands, my lord, cannot be said to be demands, my lord, of that, my lord, nature, my lord. What he is saying, my lord, that he did not supply me the documents, my lord, and he was asking for money, my lord. That will not per se, my lord, make the demand under the lord, act, my lord. Where he has to, my lord, show that I have casted the first slab, my lord. Let him show any communication, my lord, that he had casted the first slab, my lord, and made a demand, my lord. That has not been, my lord, done, my lord. This is something, my lord, he has said that Lordship sees evidence, my lord. He said that, my lord, he has, but instead of providing required documents, my lord, next, my lord, paragraph, my lord, he has specified what documents have not been, my lord, submitted, my lord. 4, my lord, paragraph 4. And NOC, allotment letter, demand letter. That's what he's saying, my lord. So this is to be qualified. This cannot be read in isolation, my lord. There's evidence, page 69. My learned friend is referring to, without referring to page 71, my lord. Paragraph 4. About, my lord, 5 lines. But till then the respondent fails to provide the complainant the said papers, that is NOC, allotment letter. If the allotment letter is not given, demand letter, etc., the reason behind it, only the respondent know better. So therefore, that has to be, these 2 lines have to read together, my lord. He cannot just pick up one line and say, my lord, that the demands were made and, my lord, no documents have been, my lord, asked for, or, my lord, no documents have been specified. That's not correct, my lord. He has specified the documents. They have failed to, my lord, even issue the basic, my lord, allotment letter, my lord. And my learned friend is talking about, my lord, he being a sufferer, he is utilizing my money, 10 lakhs he is utilizing, and he is saying he is a sufferer, my lord. And who, my lord, controls the building, my lord? He controls the building, my lord, construction, my lord. I do not control. He has to inform, my lord, that this is being done, this step is being done, that this is not the money you pay now. That he has not done, my lord. He has not been able to show anything on record. So these submissions are factual submissions which cannot be raised for the first time in a second appeal, my lord.
My lord, if this proposition of the my lord tenure is taken to board, my lord, then, my lord, equally I can say, although that I can highlight, my lord, because if they are saying that some document I have not submitted, not furnished to him, my lord, what is that demand letter, my lord? What is that demand, my lord? Even, my lord, he is saying that the bank has required document. What is the letter sent by the bank that you have to submit this document? That also he has not submitted, my lord. If his contention, which is his specifically stated by oath, my lord, before the read that I have the demanding money, that part can ignore. But, my lord, similarly, my lord, he has also not placed any demand, my lord. Even there is any single letter from the bank that this document have to be submitted by you. That document also not furnished before this authority, my lord. Therefore, I am saying, my lord, he is saying, my lord, that is on oath, my lord. And same time, my lord, he is also failed to bring before this court till this proceeding, my lord, that this is the letter from the bank. Bank has asked this document, and this document you have not furnished, my lord. Even there is no requisition from the bank also, my lord.
Bank doesn't make a requisition that way, my lord. Bank doesn't make a requisition, my lord. I require this document for myself. You have to give me these documents to me, my lord, without my requisition being there, my lord. I did not make any requisition.
Then, my lord, if he wanted to formality from me, my lord, he have to observe that formality, my lord.
Formality has to be done by
Otherwise,
you.
my lord, he is saying by making this statement only, then we have to believe him statement. But his statement, my lord, which is given by the owner, that we are not believing, my lord.
And you failed to counter those, my lord. Who was responsible for that? You did not contest the case. You could have cross-examined and found that out. Now in the second appeal, you cannot say that, no, you ought to have said this, you ought to have said that. Now, what he's saying now is the second appeal. That's what I'm trying to point out, my lord. The facts which my learned friend is trying to rely upon, my lord, this cannot be raised in the second appeal. Questions with the evidence which was given, my lord, that he has not, my lord, cross-examined then at that point of, my lord. Did he, my lord, cross-examine and say, my lord, that you did not produce any demand letter from the bank? That was not his cross-examination, my lord.
No, that
never I have said, my lord, that these were documents only required by the bank, my lord. You have to give me the NOC, my lord, the allotment letter, my lord. How do I make further payments, my lord? So therefore, these questions, my lord, this submission my learned friend are making, my lord, it would have been a very nice submission, my lord, had it been a first appeal, perhaps, my lord. But in a second appeal where substantial question of law is being heard, my lord, how can you raise these questions which we have not raised earlier, my lord?
That is my lord, crux of the case, my lord. That my lord, respondent is standing before the RERA on that point only, my lord. If that crux point is not discussed, my lord, in the event, my lord, there is a right to in this stage also, my lord. Because, my lord, that is the crux, my lord. On the basis of that claim, he has stand before this RERA, my lord. Now he is saying that this is not required, my lord. Even there is no part of this agreement, then I have to supply this document whichever his bank wanted to him, my lord. Or only that he can only know, my lord, what document is required, my lord. Otherwise, my lord, some document, my lord, plain layout, my lord, what is it is under the public domain, my lord. That is not my personal document, my lord. And my lord, if my lord same proposition will come, my lord, then my lord, he have to show that this document he has submitted before the RERA by asking me that this document is required. I have not given to him, my lord. Then I am violated this clause. But that is not, my lord. And section 18, my lord, that compensation part, section 18 and 19, my lord, that is very clear, my lord. It is not a interest, my lord. Interest that has to be given by the bank when we are depositing the bank without any condition, so that bank can utilize it, my lord. Then interest part will come, my lord. Otherwise, I am not taking the loan from him, my lord. Or otherwise, I am also not a bank to give him the interest, my lord. That is not allowed to me also. And my lord, under section 18 and section 19, my lord, that compensation part that have to ascertain by the section 70, 71 and 72, my lord. Because my lord, that compensation, that part, liquidated compensation have to be determined by the somewhere, my lord. Even that is the 77 lakhs or that is the 10 lakhs or that is the 1 rupees, my lord. That have to be determined, my lord. Otherwise, compensation is not a right, my lord. Until and unless it is justified by the proper authority. That has to be bring before this authority, my lord. That part has totally ignored, my lord. Now, my lord, we are concerned about that interest part of it. Not about the 10 lakhs, my lord, we have to return him, my lord, because he has given that we have only take that 10 lakhs, my lord. Apart from that, my lord, I am businessman. I have to take loan for construction of the building, my lord.
You are on the interest out of compensation.
My lord. No, my lord, I am not saying that it is interest, my lord. Absolutely, my lord. Even, my lord, I am submitting that it is not a interest, my lord. Even I am not liable for pay interest. Even I have no authority to pay the interest on the 10 lakhs rupees. Because it is not other specific deals. It is the specific deals under the statutory law, my lord. And that is specific compensation, my lord, stated in section 18 and 19, my lord. 18 and 19 is very clear, my lord. That if it is reflect under section 18 and 19, that compliance of the 72 is required.
Obliged, Lordship. But perhaps Lordship will have to formulate the questions of law, because since if normally when Lordship raises
that law would have been formulated, but it was not done in sufficient number law where
Well, though he has submitted, but lordships have to formulate these questions first, whether lordship will hear this.
by the time of the order it can form.
My lord, that will be done, my lord.
Otherwise, that is
I'll leave it to lordship, as your lordship pleases.
the question of
The lordship has heard it in detail. That's also true, my lord.
yes.
Otherwise, my lord, still it is second appeal under section 100, but read with section 58 of the RERA Act, my lord. In regards to the payment of the court fee, Honorable Supreme Court has decided that that much of the strictness is not required, my lord.
That is a different issue. That's a different
Regarding the
issue.
deposition of the court fee, my lord.
That has got no connection with this case.
Now, considering that, my lord, it can be said that, my lord, there is some concession in second appeal, my lord.
Though that has got no relevance.
No, even my lord, fees can, statutory fees can waive, my lord.
My learned friend making a lot of submissions which have got no relevance. Anyway, deeply of the lordship.
Okay, then community
Or if your lordship finds that there is no substantial lordship, then dismiss that. Deeply of the lordship.
No, sir.
Madam, it is a testamentary appeal filed by the appellant. And now, in this case, there is a food pending before the learned civil judge number 3 Kamrup Metropolitan Guwahati. Among the legal heirs of the testatrix who execute the will. During pendency of the will, title suit being title suit number 215.
order column, but by order column,
Your Lordship, I am appearing for all the respondents.
all the response.
All the respondents. Your
No.
Lordship, as there is no stay order also, at the same time, LCR may be called for, Your Lord.
You have received the LC. No.
Let the
No,
LCR may be
The
called
LC
for.
is awaited.
My lord, my submission is
Yes.
that suit has been proceeding. A title suit is pending.
Yes, yes, yes.
Outcome of this, the present testamentary appeal is outcome of the civil suit. There is a 6-year partition suit. 6 years is there. During pendency of this title suit, being title suit number 215/2019, will was executed. That will has challenged before the learned additional decisions number 3 Kamrup Guwahati, and appeal was probate petition was allowed. Probate suit was allowed. During probate suit, present suit was kept in abeyance. After passing the order, judgment and decree, which is challenged before this honorable court, then suit was proceeded. But during pendency of the suit, probate petition, probate title suit has decided. That point was raised before the probate court.
So probate is already decided.
Decided.
The other will is also executed. After
Yes, yes.
probably.
Yes.
Now what is pending?
Now shoot was pending. Is a partition shoot.
Partition shoot is
Yes.
still pending.
Pending. But during pendency, will was executed, and that was challenged.
Of the partition shoot will is executed, the province is also granted.
Granted. And now, present testimony appeal against the property title suit, and shoot is pending. That was proceeded with now. That's why it is required for stay.
Also, there is no stay in the matter.
Now
So,
the petition, I have filed separate application for stay, but due to illness, the same could not be filed.
your lordship LC may be called for first. Then
At the first
No.
prayer for stay was not there.
Yes.
So question that have called for the LCR. The evidence of
Yes.
So that time we remind that so it's from Campo Petron.
yes, come on, ma'am.
That gets within or 1 month record.
But till then, stay may be granted. Further proceeding.
No stay as there is no application has been
Why?
filed.
Because that point is my appeal is on that ground. Section 52 of Transfer of Property Act. Whether during pendency of the suit,
But before filing, before
This is case of suit at present.
no, it-
Partition shoot is at present.
for preparation of preliminary decree and thereafter final decree. Yes, suit is a partition suit.
The order has
Judgment
not
was passed.
for the preliminary decree.
Yes, judgment was passed. And at that time, Testatics was alive at that relevant time. She was one of the shareholders. That share has transferred.
your lordship, how can they grant for the stay? They let them file the due process of the law for granting the stay. But right now there is no stay, so LC may be called for, and then later we go
No,
for
I will
hearing.
file a ticket application.
Of that court below. What case that already order is to pass for preliminary decree.
I'm not aware of that because I'm
Yes,
not,
pass.
Has already
Pass. But decree
is not been prepared now.
not prepared. And thereafter final decree ought to have prepared.
Preparation will final decree January.
Yes.
Preparation will preliminary decree January. Final decree will come.
During that
Yes.
period, will was executed.
As call for body. We call for the LC.
call for the LC. S.A. Bhakhtiar for NLM. For all the respondents. We have filed for all the respondents. You're also
that part of 31. The minute there is any there, we can just by the interpretive fault. And by the time we exchange, it may hurt the matter.
Yes, fine. Obliged.
It is your lordship. Here, my lord, the company is receiving some funds, my lord, within 30th of May, my lord. So we are ready to pay, my lord, the area amount, my lord, of ceiling rent. So, my lord, till 30th May, my lord, may be granted. And there, if they are not opposing, my lord.
What? Why? I for it?
Lordship.
I is for?
I is for, my lord, earlier stay was vacated for continuation of their stay, my lord.
It was vacated.
Yes, my lord. So, my lord,
Appeal is pending. On the last occasion, Lordship has agreed that the matter will be heard at RFA. Is finally decided.
now situation is that, my lord, we are receiving, my lord, company's legal manager
Money,
also.
it is not a money suit. It is a suit of ejectment. Ejectment on the ground of defaulter as well as our area rent. So their part is to pay the area rent. They will pay it. I am not on that, definitely. But because of this stay order, earlier order is there. Order was conditional order regarding payment of the rent. They are not paying it. That is the stay order was vacated automatically. We started execution. Then they come and file a next IA application. And now they are claiming that since the days of Israel till today, they are not paying not a single penny. Now they are claiming that they are going to pay, they are going to receive an amount from the authority or company or otherwise. On one source, they will get it and they will pay it. It is up to them. So I am not on that. Definitely they are
No,
paying.
my lord, we are giving we are given a time, my lord,
They will
before
pay.
30th. Before 30th
They
May,
will
my
pay.
lord,
They are liable
we are
to
going
pay,
to pay,
they
my
are
lord.
paid.
And company's legal manager is also present, my lord. So till then, my lord.
Mr. Punya is that will pay.
He will pay.
My lord.
That is
No,
another-
that
With other
was
aspect.
Lordship may record. Lordship may record that it is my submission
So
on
for
behalf
the-
of the company that we are going to pay. If it is not paid, my lord, that
Then what about the other prayer?
Other prayer regarding ejectment?
Rejectment, my lord, that will be, my lord, on the next day of hearing, my lord. So, if, my lord, if they are receiving the rent, then
So
why
the
this,
matter
my
may
lord,
finally,
eviction?
it is to be taken as a part heard, and the
Part
matter
heard.
may be finally heard. RFA matter.
My lord, ejectment was, my lord, due to, my lord, non-payment of rent. That is
It
true,
is
my
an
lord.
admission decree.
My lord. So, my lord, we are going to pay
Admission decree
the
is there. In the
rent.
return statement,
If
they
possible,
agree.
my lord, we will pay the entire rent, my lord, before 30.
Payment of entire rent is not a matter. They are to liable to pay, they will pay it. It is not a money decree. It is not a money decree. They agreed, they admitted in the return statement that they defaulted in payment of rent. We filed an application before the learned trial court that the matter may be passed, that the decree to be passed on admission. Against that, they prefer a revision. And the revision petition, the Indian order passed by the Honorable Court, it is held that they are liable to pay the area rent. And they agreed to pay it 30 lakhs. Initially, they did not pay it. Now, it is an admitted position that they are defaulted. What remains to be proved? So far, the appeal is concerned. And admittedly, till today, they are not paying it. Now they are giving an assurance before the Honorable Court. We are going to pay the amount within 30th May because we are going to receive it. It is your burden. You will pay it. So far, the ejectment part is concerned, that the execution case is stayed. Execution case is stayed. And taking advantage of the stay order passed. Subsequent stay order. Earlier stay order is vacated. In the mix, in between the earlier application and between the present application, there is another application. And that was withdrawn by themselves. Because conditioning that it is not maintainable. And subsequent application was passed, has been filed. This is pending before the Honorable Court. Now they are going to say we are going to pay it. All right, you are going to pay it. You are to pay. It is your liability. You are to pay. But so far the ejectment part is concerned.
For ejectment, my lordship may hear the matter after payment, my lord.
After
I'm paying on behalf of the company, my lord. And today, my lord, Mr. B.D. Goswami, my lord, today Mr. Goswami has also some, my lord, truth problem. He has to take, my lord. So,
I may agree that maybe some problem. So the
in the meantime,
so
my
the
lord,
appeal
till
part,
30th, my lord, will pay clear.
no, he will pay it. There be order that within 30th he will repay the amount. He will pay the amount within 30th of May.
Stay was vacated due
So
to
the
default, my lord.
So far that part is concerned, appeal hearing part is concerned, that is to be heard. And that may be, on the last occasion I have argued, so that may be that the part heard matter, and the date may be fixed for hearing of the appeal. It is to be noted that only within 30 they will pay it. I am not on that. Definitely, my learned brother assured before this Honorable Court they will pay it. Because since the filing of the appeal till today, they are not paying it.
Now they
Now they will pay. Second set of advocates.
If, my lord, they are receiving the rent, my lord, what is the problem? My lord, company has more than 100 employees.
Receiving the rent,
My lord,
problem is what happened.
They have infrastructures, my lord.
I am now, they are liable to pay more than 2 crores of rupees as the area rent. And now they are claiming invoices of GST. If the GST invoices to be obtained, we have to pay the 63,000 per month. And we have to submit it. And they will withdraw it. This is my problem.
If a company is going to pay the rent, then my lord.
Two
So
crores
after
rupees.
past 30th of May, any date, my lord, for lordship may dispose the matter, may hear the matter, my lord. Finally, hear the
Before
matter.
that,
Until then, my lord.
before that, their assurance will be that they will pay it within 30 days, within 30 months.
But
It is the area rent.
earlier stay was conditional. You have to make the
I
payment.
am not on stay.
If you may make default, my lord, then your stay will be vacated. Or their stay was vacated due to default. My lord. There was some unavoidable circumstances due to which my lord, company could not pay, my lord. Now, if the company, my lord, pays the my lord, area rent, my lord,
Then they will, appeal will survive. Appeal will survive. Does it mean the appeal
so I
admittedly,
am praying for my lord a day
admittedly,
after my lord, immediately after my lord 30th of May, my lord.
both the matters to be placed together, fixed to get to, in a date, and the appeal may be heard.
Then 1st of June, my lord. May, June, my lord.
May.
30th May, my lord, we are paying. Then 31st day of May, my lord.
Before that, appeal, there's no problem for hearing the appeal. Because their liability, they will pay it. For payment, the appeal not to be pending. Or, yes, area rent. So, in the midst of the May, either 13th or 15th.
No, I am praying, my lord, on 30th day of May or first day of June or third day of June.
Hmm?
The senior has
Or
also some
13th,
problems.
13th Monday, 15th is Wednesday.
Today he is having some today. It has to be removed, my lord. This my lord, so my lord, and my lord, he has some. So he is paying for on 30, before payment date is 30th May. We have made issuance. Tourist also 31st day of May, my lord. Hearing date.
First, second, payment part, I'm not on payment part. Earlier committed. That's the either amount which they are liable for. Picture of hearing of the RFA. That's it. Okay. That, some problem.
Lordship.
Now. So by if it is covered by that, I mean 30th of May. But
13th up to recovery is not necessary
No,
for
no,
it. He wants time to make the payment up to 30th. For recovery of BD Goswami, so much time is not required.
That is okay, my lord.
So it's not required. So I am on that matter may be heard on 15th or thereafter. And so far the remaining for the payment of area rent concerned, that may be fixed on 30th. I am not on that because they have to pay it before the trial court. With the area rent.
see this area of the I is for effect the I for pre for C.
Continuation of the earlier stay, my lord. Earlier stay was vacated due to non by the
It is around pre for C and
continuation of that stay, my lord.
And the RFP for the that one. Now, if that the payment part record the I only.
I am, yes, I am.
And 30th of May, look at
For hearing.
Hearing
of the RFA. 15th of May.
Of May is
16th. 16th.
And I then it will be 4 to 10. In that case,
So for the hearing of the appeal is
So
concerned,
I am paying on
the
31st.
hearing of appeal is concerned is different part. So the IA is concerned because so far the IA is concerned, it relates to the execution. Relates to the execution. We are not going to. So up to 30.
So
Up to
if
30.
payment is made,
Yes.
then why it is execution first?
No, no.
okay, it's here. Yeah. What did- what's the- debate what what is it? No, I
Double.
May it please, your lordship. My lord, I will take your lordships to IA 2303 of 22, my lord. Order dated 24/4/2024.
Oh, it was already disposed of.
No, 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 but it's still there.
No, it wrote it.
2303/22.
See, it already
IA 2302, my lord. 2302, my lord. Oh, 02 and 03.
Correct.
cannot having
Just I am confirming, my lord.
one is 3042.
No, we are not on that, my lord. Yes, yes. My lord, 2303, my lord, of 2022. Order dated 24/4/2024. That order is by Honorable Justice Kaketo Sama.
There was disposed of.
Uh,
So I don't know if there is
No, I think
order,
it is open,
order
my
is
lord.
there.
Next,
No. One order is there on 11/8/2020. One order passed.
after that, your lordship will find
Admitted
24/4.
when the above was the ISS.
I am not on that, my lord. Justice Sema has passed on 24/4.
No. I know we have done, but on 11/8/2020 it was disposed of.
Right.
And again it was put up on 24/4.
Exactly, my lord. There was an order, my lord. That order, your lordship kindly see. My lord, there was some miscommunication from my client to me. That was a oral communication, which I misconstrued, thinking that, my lord, the money was not deposited. In fact, 30% was deposited. Now, in that context, my lord, submission was made that money was not deposited, and therefore, my lord, we may be given 2 weeks' time. We want to file a modification application. Well, on the next day, I had a talk with my legal officer. I had a discussion with him. Now, he said, and he has given me that order, saying that it was deposited long back on 18/8/2022. Therefore, the submission made on that particular date is not correct submission made.
you have already paid.
Already deposited 30%, that is 12 lakhs and on. This is before the registry, my lord. So the order passed on 24/4, my lord, that may be modified to that extent, saying that the submission was not in terms of the, my lord, instruction given by the company. In fact, it was paid on 18/8/2022 itself.
There was no any kind of debate yet for withdrawal.
No, it's not there.
They have not come with that.
They have filed a petition, my lord. That petition is also not clear. They have asked for 50% without annexing the copy of the order of dishonorable court. And in regard to that, for withdrawal, my lord, we have our submission, my lord. That this order may be rectified. After that, my lord, that argument can be advanced. What?
That what about what part about that one I just put actually what has happened is this
I understand,
was disposed of.
rightly.
Now again it was put up on 24th.
Look, this order ought to have been passed in some other IA, that is 30 something.
And
Look,
we paid an alternative that
Yes, yes.
notification that.
Yes.
So you have paid. You have filed another I.
Yeah, 3042, my lord.
30.
my lord, in regard to that, my lord, without making any argument, my lord, if my learned friend is agreeable, I may concede to the extent of out of 12 lakhs, 6 lakhs may be allowed to be withdrawn. Otherwise, my lord, we shall have to go for detailed argument because as your lordship is aware, there is a notification by the
30% amount is what is the amount of 30%?
amount is 12 lakhs 18,000. Out of that, my lord,
What's the amount?
12 lakhs 18,028.
12 plus 18,000.
Yes,
28.
28.
This
Out of that,
30%.
out of that, my lord, no, this is 30% of the total principal
Yes,
amount.
30%.
Now, my lord, we shall concede to the extent of 6 lakhs to be disbursed to them, if he is agreeable. Otherwise, my lord, we shall have to go for argument of the case in the sense, my lord, your lordship is aware, there is
That's why
a
that they talk about if this is not 50%, it's only 30%.
No,
And from the 30%, again, you are going to give 6 tax, that is only 50%.
there is a reason to it, my lord, because the other day I have argued before your lordships one matter. My lord, the state government has given a notification that when a person dies, till the date of his superannuation, exactly he is placed on that. So therefore, I will have to make that argument once again. So without making all such argument, my lord, up to 6 lakhs is agreeable. Your lordship may allow to disperse at this stage.
At least more than 6 lakhs may be considered, Your Lordship.
My lord, considering the
bank loan
legal
interest
point,
is
my
there.
lord.
Bank loan is there.
Not of that.
I
Now,
respectfully agree.
as per government notification,
Yes, yes.
the salary
Yeah.
will be because by the
Yeah.
that is the law now or
Yes, yes.
but that's why it is that one. And but uh, is ready to pay 6 lakhs.
Yes.
As a then you pass an order.
Yes.
Yes. So here by the rate for 50%.
50%.
Okay, then up to 6 lakhs will pass the order.
Yes.
And Metro will be most of the Metro.
Yes.
And then what stage of MSC they appeal? No?
I think
Appeal is ready for
I think it is ready, my lord. Already date has been fixed. I think 28th May. Last
Yes.
week.
Date is fixed. On 28th May.
already. Oh, right. Uh, uh, that this order cannot be uploaded now because it's already disposed of matter.
My lord.
It is already shown in the website that the matter has already been disposed.
Right.
So now this order of support authority or what your submission they have recorded that cannot be uploaded in the
It's not necessary, my
system.
lord.
No,
It may not be uploaded.
Not uploaded, suppose that case you will not get a certified copy of that order. This
Oh,
order.
so that will be again.
Again it will. So now we are in a position now we cannot upload the order. Right.
If we
So-
get the certified copy, then no problem. My lord.
Then our purpose will start.
Because the registry will ask for the certified copy of the order.
But that point was raised from your side only.
My lord.
That 30% you have not paid the deposit, 30% amount. That's why I was saying that the amount that we
Right.
pass the order.
Yes.
But if that sorted,
No, but then there is an order. My lord, I have other day I argued that I will have to file a modification application. So that order is there. And unless we file that modification application, after 2 weeks it will automatically dismiss. So I am at the receiving end. Therefore, this order is required to be modified.
any because question is not uploaded, suppose you won't get the certificate.
Or other
Certificate copy that or otherwise we can do one thing.
one true copy can be, my lord, I think given. I think registry will accept that.
If you are kept, I'm not aware of it.
I'm also not much aware of, but
My lord, kindly have a look of paragraph.
Or can oh no, that case also there was an order for otherwise I thought that your certificate or whatever you are putting will while passing the order in his eye
yeah.
can incorporate all these things. That certificate is also the for public. You are ready to and if they are not receive that with return back. This can be
That part is okay, but then Justice Sema's order will be in
but
between.
Justice Sema's order is not uploaded.
Uh,
Not yet up. We have checked. Not yet up.
Uploaded, yes, my lord.
No, not
I've
yet up.
got it. I've got it.
Justice Sema's order on 24/4 is not up.
My lord, yes, yes, it is. I have got it. 24 for 2020.
Okay, we have prepared the order. Will let us
My lord, yeah.
verify the thing. And if you can get 2 copies of the order, then it's up to you. I don't have it.
My lord.
That it cannot be updated, we may not get that.
Yes, yes.
And otherwise, incorporate all people submission in IF at the HIMOT.
My
That
Obliged.
calendar is not here.
May please, Lordship. I filed this appeal.
And I filed this IA 613/2023.
Your I number is 6.
613/2023 with a prayer for modification of the order dated 13/2/2023.
You are on I 613.
Yes, my lord.
Modification of order date.
13/2/2023, page 26, my lord, of IA 613 IA,
In page number 26.
page 26.
Yes.
Now,
Was the order?
after this order, my lord, after this order, till returnable date, the operation of the judgment and award for so and so shall remain stay. But after returnable date, my lord, I filed this IA, and my prayer is to vacate the or stay order on the ground that petitioner has been suffering due to lack of family members of the family, because the only son of the petitioner who died on 26/3/2016 on the spot at the time of accident.
So basically, you file the present I for vacation of the stay order.
The same. At the same time, a prayer was also made for release of the 50% of the amount, my lord.
So how can you make there?
Very interesting. I filed an appeal. I filed a reply. Then he has started. This is very, I'm not accepting this type of. My lord, I filed an appeal. He has filed an, okay, then he has filed for modification or even alteration of the order. Then I filed a reply. My lord, my case is that. Very important case. This case is already remanded back because initially that case is filed. My lord, kindly see my reply. I submitted. I annexed all the documents. Kindly see, my lord, my reply.
No, but yes, the question is that he filed an I for stay of the proceeding.
My lord, there are two IA there. One is 613/2023. Another one is 900/2023.
Yes. Yes, I'm on 613.
Yes.
613 you have filed for modification.
For modification of the order.
Stay order.
Stay order.
Or to vacate the order.
Yes, to vacate the
Now,
order.
in the stay order, if you say that the returnable date it was stayed and then you file this one,
Yes.
to vacate the stay order.
Yes.
So in the same order, you have also prayed for releasing of the
No. In the same order, in my prayer, my Lord, I have not prayed for release. In my 900, I prayed for 60%.
So in one hand, you are going to receive the money, and the other hand, you are going to vacate the stay order.
Now, my Lord, let the stay be continued. I have no objection. But in the meantime, my Lord, at least 60% may be released, my Lord.
If I make the payment, then you'll get the 60%.
I am not going to press.
That is why my objection. Let me to argue minima, your lordship. Allow me to argue the matter. What is the
So
case?
while prayer for stay was there any condition for filing, paying any amount?
No. This judgment is itself is defective. My lord, by sitting in the MACT court, can be exercised the jurisdiction of the WC court? Kindly see this judgment.
We will come to later on.
Malik, kindly see the judgment. My objection, my lord. In my objection of the
So
learned
yes, what to say? The regarding 620, you have filed objection.
Yes. 613. Yes, I filed an objection. Kindly see this page. What is the judgment of the learned tribunal
That will come
knockout?
later on. What is your objection?
Objection is that, my lord.
No, you have filed your written objection here.
Yes. Not to. At the same time, my lord, LCR also received. That is why. My lord, case is that.
You can go for the hearing only.
Yes. Fixed on, my lord, if it is day after tomorrow, lordship, I'll hear it before your lordship. I hear it. And still is continuing.
IA 900, you pray for?
Yes.
Releasing of money.
Releasing of 60% awarded amount, my Lord.
60% of the awarded amount.
And 60% of the award.
Because case is that very interesting, my lord. Initially, that the case is in the year filed. Let me to say.
No, it's okay. We pass the order accordingly. So stay for modification or vacation of stay, and the IA 900 closed fee can be heard along with the main appeal because it is appeal.
My lord,
I am not going to press. I am pressing 900, my lord. The 900 orders.
Enter thing will be hard.
900 may be passed, my lord.
Enter things will be hard. Fix the day after tomorrow.
No, the question is that the 900. Suppose if an accident case of an award was passed wherein some sort of thing is admitted by the insurance company or the claimant or whatever.
I'm not admitting.
But here in this case, challenge the entire judgment. Basically, that it is not passed
not
under
payable.
the proper forum and so whatever.
My lord.
If their grounds are there, it's not a legally tenable judgment passed by the. So in that case, most probably if you file praise for a 60% of release of the awarded amount, they may raise an objection in that case. So that's what I am saying, that if the entire matter is disposed of, because it is of 2023 matter, then most probably if your claim is there, then
my subject to correction by your lordship, if I am not mistaken to say, it is very difficult to list the case in the hearing first.
Lordship will fix the matter.
Not reaching. Even today I have two cases in the code number 16. It is not reaching.
No. My lordship.
That is the difficulty, that is the difficulty, my lord.
Lordship, fix the matter within 15 days or 9 day after tomorrow, 2nd of May or 9th of May or 17th of May. I'm giving the three option. You'll get the entire money. Very peculiar judgment. I got it my 25 years here. MACT. He's sitting learned tribunal on the basis of the WC code because that is not maintainable. This claim petition itself is not maintainable. It is
my lord, let it be very good enough. If the maintainability of the appeal is a question before this honorable court, let this matter be fixed.
Yes, that is why I'm saying. Lordship also.
If my learned colleague is insisting for maintainability, I will be very happy enough. Let this matter be heard just now by your lordship. I am ready. Whether it is maintainable in the eye of law or not, if it is not maintainable, let this matter go. Dispose of.
I'll fix it. Lordship,
I'm just now, this court is perhaps free enough. This court may pass order. Any order, I am ready.
So 613, you are not going to press this one.
Now, just now, I am not going to press. I am going to.
In a sense, it will be continuing or.
Let this interim order be continued. No problem from my part. But my 900, I am going to press, my lord, because parties from 2003 matters, my lord. and they have lost their son. Even the father also is a claimant who expired also.
My lord, let me say something, my lord. It is a
Who expired
2003 matter. It is wrongly filed in the MSCT court. It is a 302. They have filed under section 166. Initially, the judgment was passed in the year 2015. Rejected the claim petition. They have filed that appeal. Then appeal was decided and remand back again to decide as per the law. But the learned tribunal could not find that law. He has come to the jump to the sitting in the MSCT court. He's followed the WC court.
This is a defamatory statement.
Yes.
I respect.
Why are you saying that? Let me to say.
I respect because I am not going to lower court. My learned colleague.
You
also,
don't know the law. Let me say how we can say that it is defamatory. You are not attending the WC court. I am attending the WC court.
Amount to defamatory statement against the judge.
Kindly see this judgment, my lord.
That type of statement is very bad.
Fixed a date, my lord. And fixed a date. On that day, my lord, everything will be clear.
There are some instances, I don't know about this judgment, what is this or what is the
Yes, my lord.
thing, I
At
don't
this
know,
stage.
but there may be 302, I do not know. But
My lord, I want to highlight the
person
fact.
is died, suppose
My lord, if I am not
using out of the vehicle and all that can be missing.
That is recorded receipt.
So that may be there. I don't know this.
My lord, I want to highlight the fact so that your lordship will be enlightened. What had happened? This
my lord, fixed a date because
We are here for up to 3
yes,
only.
yes.
So
fixed a date, my lord.
Then
Fixed
fix
a
a
date.
date, my lord.
Fixed.
I am giving the 3 date. Day after tomorrow, with your lordship,
wait, you are giving-
or 9th
we
or
have
17th.
We have given. No.
Day after tomorrow, maybe kindly fix, my lord.
I am ready to.
Okay, we are given. And- If I 6 1 3 6 1 that will work. And MS 41 otherwise we have received here now.
I file an also objection. Also.
Very happy.
I file an objection in IA number 613.
This will come at the
Yes, my lord.
in I not I so did there any question of any other response?
No.
Okay. We want to fix it?
Yes, my lord.
30.
30, my lord.
We have
30,
30.
my lord. Can be. May 30. Well, if it is 17th, 17th of May, if possible.
Not the hearing day and
It is a hearing day, my lord. 17 is a hearing day.
17 is a hearing day. It's a Friday.
Yeah, my lord, if it is possible, day after tomorrow, no
May
problem.
not be possible.
Then 16, my lord. 16 is a Thursday. Will you update the matter?
It's of course a Thursday, but four part there I think it was. Okay.
Lordship think for the 30th. আরে
Yes,
কথা
yes.
বল না ভাই আমার কোন দিন পেব না
No. Eight.
আরে আমি দিন আপনি যখন কথা কোন আমি কিছু কই
No.
ভাই সেইং
Okay.
23rd of May is the holiday and 22nd is the weather. Friday that 24th should be on 24th only. Otherwise, we don't have
my 30th no problem 30th of May
24 you have a problem.
24 man.
It's a Friday, but to be
Yes, 24 email.
Because
24th
there
of May.
will be less number of hearing matters.
My lord, no, 24th May.
Right.
My lord, 24th of May. SC has also received and stay order shall continue.
So, Doctor, in item number 17, what we have said that the order was passed by Justice Sema in a case where he has already been disposed of. So, knowing everything, how can we pass the order? So that's why what we propose that in your eye that there may be a reflection that 30% has already been deposited as to pass wage, and he has no objection if this excess is released in your eye. That may be passed. So we are just I want to inform
As Doctor.
as Dr.
I'll inform. No? It will be, my lord, it will be wise enough to pass the order by the Honorable Justice H. Kesema, if he has passed the order.
If he has passed the order?
Yes. My lord, the order by today, we have discussed this case along with S. Dotto, and we are almost on the part of last point that your lordship will pass the order. But I think my suggestion is that it is up to your lordship. It will be wise enough to pass the order by Honorable.
In your eye will pass the order.
Yes.
The IA fell by you.
Yes.
Not the IA, the earlier disposed of IA, we are not going to pass the order. The IA which you have filed by you. By you.
Yes.
That in that case, we can bring all these things that 30% has already been deposited. After 30%, if tax is released in your paper, you don't have.
Then we'll serve the purpose.
Much
Okay, we'll
obliged.
see. We'll talk to you.
Obliged.
Much obliged.
May I please? Service completed, my lord, regarding this case. Office note, my lord, 26/4/2024, my lord.
It's here. Okay. Yes.
Service completed in this
Service
matter,
is
my
already
lord.
completed.
My lord, regarding respondent number 1 to 5, my lord. They have also Wakalat number file by office note dated it is reflected 26/4/2022.
Four and five. That's not.
Matter already statement. Next to hearing, my lord.
Otherwise, five respondents are there.
5 references. They have also filed Wakalatnama, my lord.
Yes, sir.
They have at the hearing. So it is for returnable, my lord. SC.
SC.
Yes, ma'am.
SC. As per the 26/4/2024, the 1/5 Wakalatnama is also filed on behalf of 1/5 and number 4 and 5 at the recording board for number 1. That's of the number. That's it for immediately. We are calling for the
My lord, my lord. Obliged.
What I want to just ask you, can it be completed within half an hour?
Not my
In
lord.
that case,
Not
may
my
not
lord.
be-
At least 1 hour will take.
1 hour may not be possible.
You will take 1 hour, and I may take more than 1 hour.
And I just I just ask you because I do not want to keep it as a part head also, because my bench is up to 3rd of May in this principal seat. They're after that I don't know, but with my bench, so it should not be part. That's why I'm asking. If it is half an hour, then I'm ready.
No, it's not possible, my lord.
Not
Probably he
possible,
will be referring to 3 or 4 judgments. I will be referring to 4-5 judgments.
Otherwise, it's the case of 2017, in fact. So, it is 17 matter.
On 17 May.
17, 16, 17, 17, the
Friday.
17 is Friday.
Friday. We're going to fix it on 21st of May.
Yes.
Can it be on 28th, my lord? 28th.
20th, the hearing date?
Yes, yes. Hearing.
Okay, then it is on 28th. 28th.
Problem is that I'm going.
Same difficulties, my lord. More than 1 hour. My lord. Today's
You know, I think we have a reference from Mr. Justice Saikya.
my lord, my lord. It will take time. After verification.
I can hear one part, but it again that should be at the part third. Part third may create a problem until this match is developed.
Oh, my lord, 19 meter, my lord. So, yeah.
19 meter.
There is an order that method out of turn order is there. So a date may be fixed.
July 9. After verification. It is
So it be month of June, first week of June or second week of June?
second of June.
Second week of June commence from
10.
10.
Some urgency in this.
On 13, my lord, 13 June. May month date 9. Okay,
Letter week commence from 10.
my lord.
10.
10.
Yeah, you want fixed date, in fact.
10 Monday, my lord.
No, Tuesday can be given at 11th of June. Oh, 11. Based on 11.